All right, good morning and thank you for joining me today. May 1st, they launched a brand new listing agreement. It's really not brand new. It's been altered enough so that it coincides or runs more parallel to the purchase contract. So a lot of the things we saw come up in the new purchase contract referencing the seller have been incorporated into the listing agreement. It is another page longer, surprise. But it does have a little bit more clear and, like I said, parallel connection to the purchase contract. So I'm just going to go through each paragraph here. The contract itself is available on the board site. And to get to the board site, you have to go into that portal, cabr.org. And right here, usually this is not shown, but if you click on the right-hand side that says View More, you have access to the CABR site, and that's where that form is. Once you sign into the CABR site, you can go through the list of documents and pull up the exclusive right to sell. There was also just a summary of the changes that were available. I will include this with the email of the recording of the video, okay? So that you can go through that. But moving forward, paragraph number 1 is the appointment of the realtor. It does specify the time that you're listing the property, or I'm sorry, signing the listing agreement, as well as the expiration date. The biggest change here is they have included the lines here to input the partial or tax ID number, because that's now required on the purchase contract. They're also asking it to be put on the listing contract. Still has the price here. It also says here that the seller, this is another change, the seller agrees to delegate the realtor the authority to appoint other licensees within the brokerage to represent the seller's interest. If an appointment is made, seller will be notified at the time of the appointment, and seller has the right to veto the appointment of any other licensee. So for example, if you were maybe stepping back from listing, you decided you don't want to be the listing agent for this, or if you actually have a team member that you want to take over the listing, the seller has the right to veto any change you make to that representation. All right. So that really would have to be discussed with the broker and the seller and be as transparent as you can for whatever reason. Paragraph 2, the realtor acceptance is the same. The realtor accepts an employment and agrees in consideration of agreements by the seller to use its best efforts to sell. Paragraph number 3, which is the inclusion exclusion, has been updated to be more with the verbiage of the purchase contract, which just talks about the appliances as well, excluding, of course, any countertop appliances. But it does state here that it shall include ranges, ovens, microwaves, refrigerators, dishwashers, garbage disposals, trash compactors, unless specified. In that line 35 in the same paragraph, we actually have to now list out those appliances. It was just check boxes before. You're actually going to list out that. In the event of a conflict between this section and any subsequent purchase contract between seller and buyer, the subsequent agreement shall control. Okay. Number 4 is any other items that will be included in the marketing of the real estate for sale. Maybe they have, you know, a wine cooler they want to include, or maybe they do want to include some countertop appliance. They would list it in that. Paragraph 5 is the certificate of ownership. This is just certifying the seller owns all of the above real estate and all other items included in the sale as listed in section 3 and 4, and they'll be free and clear of any debt, lien, or encumbrance at closing. Paragraph 6 on the next page, it still requires, I'm sorry, on the bottom of every page for the seller to initial with date and time. Paragraph 6 is a possession and occupancy. This has been updated to put the seller more on the spot and in the position of responsibility that if they fail to vacate as agreed in the contract or any post-occupancy agreement, the seller shall be responsible for the additional expenses, including attorney fees incurred by the buyer to take possession as a seller's failure to vacate. It also states, and this is updated language too, that if the inspections are waived, the seller shall provide the buyer the opportunity to conduct a walkthrough inspection of the real estate within 48 hours prior to closing, solely for the purpose of ascertaining the seller has maintained the real estate as required herein and has met all other contract obligations. So a lot of, there was no specific language before that the buyer had the right to walk through unless it was to noted on the post-inspection addendum. They did away with that post-inspection addendum. They updated the defect notice. But if you waive inspections, you don't even get the defect notice. That gives you that 2 days or however many days to walk through. Now it's in the listing contract. 7, the paragraph 7 has been updated to mirror what the purchase contract has with the seller certifications. And that is for them to select those boxes on that line there. Some things that I've noticed a few agents missing on these, this list of items for the seller certification is that if it is subject to any shared walls, driveways, encroachments, that's here on line 79, that does need to be marked here. So even if you mark it that it is in an HOA and it is a condo association, you do need to make sure that you mark line 75 as well as, I'm sorry, 79 too. And if the taxes are homestead, that's actually also noted on here as well. All right. Further on down, paragraph number 8 is still lead-based paint certification. That hasn't changed. Paragraph 9 is the property disclosure. It also states here, and this is new verbiage on line 98, that the seller understands that they're obligated to disclose to prospective buyers if they become aware of any material defects discovered after initially signing the property disclosure form. So maybe if they have a deal that falls apart and something came out of that, and it's an additional disclosure, now that would be an answer on the property disclosure, they have to fill out a new one. And maybe they have a massive leak during the listing and they have that fixed, they have to fill out a new property disclosure. Language here has now been added so that they're adhered to that.
Leanne, I have a quick question.
Yes.
Do they have to fill out a new one, or can't they just add on to the existing one and initial it with the new date and time?
They can add on to the existing one and initial it with the change.
Okay,
yes.
Thank
you. Paragraph 10, the homeowners association condo declarations, bylaws, and articles. This has been formatted to look more like the purchase contract as well, whether it's subject to an association established by reported declarations with mandatory membership, and if they're subject to any currently approved or pending association assessment. So just like the purchase contract, the language is spelled out here the same for the seller to certify. It also states here too about the 2 years worth of minutes. Right here in the bold language, starting on 112, that the documents recorded with the county, the association declaration, the association's financial statements, rules and restrictions, schedules of monthly, annual, and special assessment fees, architectural standards, to the extent not included in the R&R, the bylaws and the articles of incorporation, and minutes for the previous 2 years, and other pertinent documents as requested. So it is up to the seller at the seller's expense to provide those. So that has been spelled out now in the listing contract. Good. I think so. Yeah. Paragraph 11, the conveyance and status of title has not changed. That's the same language that, you know, they understand it has to be free of any assessments, encumbrances, liens, and due and payable by the time of closing. Anything after closing, of course, would be listed as the exception on line 127. And then, of course, on 130, they have to list all the persons, dower, ownership rights, etc., of the individuals whose signature is necessary in order to convey the real estate. Doesn't mean they have to sign the listing contract, but they would have to sign the title over at closing. Okay. Taxes and assessments are the same here. Other prorations the same. Paragraph 14, the realtor's commission. This is just the number has changed a little bit on the paragraphs, but 14 is still realtor's commission, and the seller agrees to pay whether it's a flat dollar amount or a percentage of the gross selling price, regardless of the agency relationship. Paragraph 15 is that protection period, you know, that how long after a listing agreement were to expire would this agent still be entitled to commission. Now, of course, if they list with another brokerage, that's null and void. This paragraph is out. Okay. Cooperation with other brokerages. The realtor might seek cooperation from other brokerages and agree to pay a certain percentage to any cooperating broker that has participated in the sale of the real estate as the procuring broker, regardless of relationship. How many people actually put in there just the number, and how many people put in additional verbiage? Because a lot of sellers are having some conflicting questions here when you put up the total commission up here in paragraph 14 and then say we'll pay 3%. Well, that adds up to 9. So are you specifying on line 52, 3% of purchase price included in realtor commission above? So think about that. So Carolyn, do you put that statement, or are you just putting the percentage?
I do not. I put 3% in there.
Okay. Yeah, apparently a seller has brought it to the attention of the board. I don't know where that is in any kind of mediation. It might have been resolved on that individual case, but in one of my committee meetings that was brought up, asking how we as agents were wording that. I have always put in pay 3% of the purchase price included in the total commission. So you might want to start considering that too. The civil rights paragraph 117 is the same verbiage. Paragraph 18 has just been reformatted to be more of that checkbox list instead of the straight across lines as to the listing, publishing the listing, showing the address, allowing the AVMs, allowing the internet blogging, subject to short sale, etc. Commonly on the MLS input, if you input in your own listings, some of these boxes are checked by default. So be sure that you're checking these off so that your admin or whoever's putting the contract in has it as the seller has agreed to. Paragraph 19, signs, same thing here as before, whether or not the sign is authorized. And also when it's sold, that the seller authorizes the agent to put a sold sign in there on, and the seller acknowledges and agrees that no signs, advertising, or other promotions containing language for sale by owner will be used to advertise the real estate. Paragraph 20, seller's cooperation, same language. 21 has been updated to include that unlicensed authorization for sellers to allow like photographers, inspectors, appraisers into the property. And it does specifically state here on 194, whether the seller authorizes or does not, that a buyer who's under contract to purchase the real estate and a licensed home inspector to be present for the buyer's inspections without the licensed real estate agent there. Yay. So they have, yay, they have incorporated that into the listing agreement. So, and it's in that format nicely, you know, the 3 boxes there. They also state in 22 about the electronic surveillance devices. The seller has to disclose here because this was a separate form. Now it's included in here, whether or not the seller has it located on the property, and they understand that under the Ohio law, the seller cannot use the electronic or any other device to listen, record the communication. The seller agrees that if such surveillance device is present on the property, the seller will turn off any audio feature of the equipment when the persons are present. And this applies to all showings, open houses, and any other appointment at which the prospective buyers, real estates, inspectors, appraisers, contractors are on the property. And it's advised that the seller consult with an attorney regarding the use of such surveillance devices under Ohio law. And the seller also agrees to indemnify, defend, and hold harmless the listing brokerage and its affiliated licenses from any claims, demands, actions, and damages out of that. So they do have to turn those off. A lot of them will say, I can't turn off my doorbell. I don't want to turn that off. You know, it's connected to the doorbell. That just has to be disclosed then in the listing, maybe on the agent remarks that there is a Ring doorbell that will be left on continuously. Okay, they just need to be made aware. The problem was getting to be where they'd have nanny cams in the house. They wouldn't disclose that they had them. They'd be recording constantly. And then they'd have conversations with their listing agent. Hey, I saw that those people in here. I know what they were trying to do. I don't want to take that offer, blah, blah, blah. So I personally don't know how many of you have the conversations about the house within the house. I was always really hesitant about that even before the recording, just because I just felt it was bad mojo for the house. So always have the conversation out of the house. So, earnest money deposit hasn't changed. Home warranty now states on here who it's going to be provided by and what amount it's going to be. So if the sellers are willing to provide a home warranty in place, they can agree to that and how it's going to be paid for and provided by. 25, title insurance. This has been updated. This is a new paragraph that they will contribute to such a purchase in some cases of the Ohio, owner's policy of title insurance, and they may be transferred over to the buyer and whether they currently have one or not. Agency disclosure on 26, line 218, just states the same about the consumer guide to agency relationships. 27 has been updated, that this is the disclosed dual agency, and that also takes into consideration that it could be a team member of the listing agent. Okay. 28, indemnity by seller. Seller recognizes that the realtor is relying on all that information. This has been expanded to include some additional situations, such as right here on paragraph, 233, that they are not matters in the law, professionals in the matters of law, taxing, financing, surveying, property inspection, structural conditions, hazardous materials, engineering, etc. And seller acknowledges that he or she has been advised by the realtor to seek professional expert assistance and advice in these areas. Because this was coming out a lot of inspections, the structural issues, and they were pushing back on the listing agent because the seller would claim listing agent advised them this or that. So this is just to identify us even further with that. Okay. And it's always okay to tell a seller from a past experience what happened, but make sure you state specifically that, well, I did have a seller that had this problem and this is how they addressed it. I can ask them for that contractor if you'd like, but never take it to be a professional, expertise that you've acquired. Okay. Any additional terms and conditions in paragraph 30? I'm sorry, I skipped 29. That's just disclosure. Hasn't changed any wording. Sole contract has not changed any wording, but it's reiterating that a lot of agents skip over this. Sellers are allowed in the state of Ohio to list with more than one agent, and they are also allowed to list with one agent for sale and one agent for leasing. If they say, well, I would consider leasing this, they can ask another brokerage to list it for leasing. This is prohibiting them from doing that. Right? So be sure to check that box on 251. I think by default, the office might, assume it's prohibited, but make sure you're putting something in there. 32, electronic signatures. The contract, of course, may be executed by manual or electronic signatures on any of the documents and transmitted in original, facsimile, or electronic format shall be the same and valid as purposes of the contract. Any amendments, addendums, or notices to be delivered in connection with contract. So if they sign one in ink and sign the other electronically, they're both valid as fully executed. The electronic wire fraud, this has been updated to include the verbiage that's in the anti-fraud disclosures, but I don't see that form going away because a lot of brokerages have those forms branded to themselves. So that's probably going to still be in existence. Okay. Seller's acknowledgement on the next page, 34. This again acknowledges any questions regarding legal liability with regard to the provision of the contract or a disclosure should be addressed to an attorney, any tax to financial professional. The seller's certification of authority, this just has been updated to state that each of the title owners and any additional signatures, such as a spouse for dower and the other spouse rate, require signature, even if the spouse is not on the title, or others who are necessary in order to convey the real estate, have expressly agreed to sign and require purchase or financial documents in order to convey the real estate other than the disclosed section 11 of the contract. In the event of a power of attorney, trust, corporation, LLC, or other right to transfer documentation of authority to convey the real estate shall be provided upon request. We get a lot of LLCs that will just sign LLC. They won't sign the authorized signer's name of that LLC. Every broker should be kicking that back. An entity isn't purchasing it. A person is authorized by the entity to purchase it or to list it. So if you have an LLC, make sure you ask for the LLC documents and the name of the authorized signer. The signature lines have not changed. They still have the signing name, printed name, the date and time, phone number, etc. And the realtor's information at the bottom has not signed or has not changed. That's still for all of you to sign. Any questions on that? Like I said, it's kind of short and sweet, but it does more in line with the purchase contract, and I'll send you a summary of those changes as well. All right. Carolyn, any questions? Did that help? I like it. I think they revised it nicely.
I think so too. I like that they coincide with each other, and some things I've been putting in purchase agreements under other contingencies are now in this.
Very good.
Like,
I agree.
You know, like buyers allowed to be with inspectors or contractors without a licensed real estate agent. And then I have to tell you, I have never received minutes yet. So I'm glad it's in there. So, you know, I've been giving out a paragraph to all my sellers for them to sign of everything they need to get us. But I just think now that the minutes and the extra requirements for HOA are in there, you know, the liabilities on the sellers.
Mm-hmm. Oh, and the cost. I mean, I can't tell you how many times buyers were forking out, you know, almost $200 to get HOA docs off of HomeWise. You know, it was insane.
Exactly. No, I like it.
Yeah. Okay. Hannah, your thoughts?
So normally when is the video posted?
Just after the class, I convert it, email it to Karen, and she puts it up, or Beth does.
Okay, perfect. Because I'm just going to re-go over it and make sure go over it with a fine tooth comb.
Okay. No, very good. You have to be fluid in it so you can, you know, have a good sit down with the seller and be able to go right through it. When you're stumbling upon it, they're going to be stumbling upon it. So
yeah.
Okay. All right. Well, very good, ladies. Thanks for joining me this morning. I will be at Bridgetown this afternoon, but I'll get this video over to Karen and Beth here in the next half an hour. Okay.
All right. Perfect. Thank you so much.
Thank
Thank
you.
you so
Have a good rest of your day. You're welcome. Talk to you soon.
Bye-bye.
Bye.